We begin today's review with two child custody cases. The first is Cardona versus Soto, which you'll find on slide 13. This is a case that involves the due process rights of parents in cases when a judge interviews children outside of the party's presence. In 2012, the mother and father stipulate to joint legal and physical custody of their child. In October of 2022, the mother files a request for a restraining order against the father on behalf of herself and the minor child following a physical altercation between the father and his current wife. Mom alleges that the father got drunk, beat his wife in the presence of the child, and when the child reached out to a relative for help, the father slapped the child in the face and berated her. As a result of the incident, the father was arrested and the wife obtained a restraining order against him. At the hearing, both parties appear representing themselves. Mom testifies the child made an audio recording of the incident involving dad and his new wife and states the child was completely traumatized, is in fear, and does not want to see the father at all. Further, Mom testifies that dad forced the child to carry his loaded handgun on multiple occasions. Dad testifies that he had only one bad altercation with his wife, but admits that he was blacked out, drunk, and could not remember the incident. However, he's not such a bad guy. He's been sober since the incident and is taking anger management classes and has turned in all of his guns. So they're in court, and when the judge asks Mom, this sounds like it's kind of a he said, she said, and a lot of hearsay. What other evidence do you have? And Mom says, well, our child could testify. And so the court says, okay. They continue the matter to the following day to allow Mom to bring the child into court. At the hearing, the judge and the child have an in-chambers discussion that is not reported and it's not recorded. At the conclusion of the interview, the judge does not provide a summary of what was said between himself and the child. When they go back on the record, he just doesn't do that. Instead, he tells the parties, I'm not going to talk to you about what I've learned from the child, except to say that I did hear the recording, and when father and wife were having their domestic violence issues, it was pretty awful, especially for a 12-year-old to listen to. When the judge announces his rulings, he does not directly reveal what the child said, but alludes to things that the child said in chambers. For example, the judge states that he had confirmation of the slapping. The judge also tells Dad, you seem to think everything is just perfect, sir, but believe me, things are not perfect from your daughter's standpoint. The judge issues a 1-year restraining order protecting Mom and the child, and of course, Dad appeals his decision. Well, the Court of Appeal reverses the trial court's decision, and the father is awarded his costs on appeal. You may wonder why. Well, the Court of Appeal finds that the father's due process rights were violated, and the father was prejudiced by the violation of his rights. Since there was a reasonable probability the father would have obtained a more favorable outcome had the error not occurred, the matter was reversed. So, considering this decision, we need to remind ourselves that part of our job is to persuade, convince the court to follow due process rights of our clients, particularly when handling the testimony of minors in domestic violence and custody cases. All too often, what it feels like as a family law practitioner is that there's a lot of cooks in the kitchen, minors counsel, parenting coordinators, professional monitors, and somehow, if you're representing the other parents, you feel like their due process rights are violated. I think this is a good reminder for us to stand up for our clients' due process rights. A practice tip, if you're going into court and there's going to be a minor's interview in chambers, ask that the court have a court reporter there. And the Court of Appeal suggested this, and if there's no court reporter, because LA is short of them, then ask that it be audio recorded. And if it doesn't have that, then ask the court to provide a detailed written summary as to what happened in chambers, and ask and demand that your client have the right to cross-examine witnesses and put on its own evidence and challenge the evidence.